It is done. The nuclear option has been activated. For the first time in the history of the United States Department of Justice, a sitting attorney general is facing formal articles of impeachment. And the charge written into that document is not procedural, not technical, not buried in legal language designed to obscure its meaning. The charge is explicit, brutal, unprecedented in its directness. Congresswoman Summer Lee has accused Pam Bondi of breaking the law specifically to protect pedophiles, not to protect national security, not to protect ongoing investigations, not to protect privileged communications or classified intelligence, to protect pedophiles. That word, that specific, legally precise, morally unambiguous word, is now part of the permanent congressional record of Pam Bondi's tenure as Attorney General of the United States. And Washington, which has processed a generation of political scandals, has gone silent in a way that tells you everything about what the people in this city understand about what that word in that document actually means. Here is what we know. Congresswoman Summer Lee has officially introduced articles of impeachment against Attorney General Pam Bondi, charging the nation's top law enforcement officer with defying congressional subpoenas, ignoring federal court orders, and committing perjury, all in service of illegally suppressing the release of the complete unredacted Jeffrey Epstein files. These are not allegations assembled from circumstantial evidence or partisan inference. They are charges built on a documented record of noncompliance, months of stalling, millions of pages withheld, names of high-profile billionaires redacted with a consistency and specificity that congressional investigators describe as impossible to attribute to accident. The subpoenas were issued, the court orders were entered, the deadlines passed, and Pam Bondi, the chief law enforcement officer of the most powerful nation on earth, looked at every one of those legal instruments and chose defiance. The articles of impeachment are the constitutional response to that choice. Think about the specific charges and what each one means in isolation, because the coverage of this story is treating them as a collective political attack, when each individual charge carries its own devastating legal weight. Defying congressional subpoenas is not a policy disagreement. It is contempt of Congress, a documented, on-the-record refusal to comply with the legally binding demands of the legislative branch. Ignoring federal court orders is not an administrative delay. It is defiance of the judicial branch, a sitting cabinet officer telling a federal judge that the order entered from that bench does not govern her conduct. And perjury, the third charge, is a federal crime, not a constitutional violation, not an ethical breach, a crime, punishable by imprisonment, committed, according to the articles of impeachment, by the person whose department is responsible for prosecuting perjury committed by everyone else. Put all three charges together, and the picture that emerges is not of a cabinet officer who made mistakes. It is of a cabinet officer who made choices, deliberate, sustained, documented choices, to place herself above the law she was appointed to enforce. The language of the impeachment document itself is the most significant legal and political development in this story. And it is the element that the surface coverage is processing as rhetoric when it is something far more structurally consequential. The accusation that Bondi acted to protect pedophiles is not inflammatory language inserted for political effect. It is a legal characterization of the specific individuals whose names and associations the Epstein files document. Individuals whose protection the articles of impeachment charge Bondi with prioritizing over her constitutional obligations. When a member of Congress writes that accusation into a formal impeachment document, they are not making a campaign statement. They are entering a legal conclusion into the permanent congressional record under their name, under their oath, with the full institutional weight of the impeachment process behind it. Congresswoman Lee has concluded, based on the documented record of Bondi's conduct, that the only explanation for the sustained, multi-layered, legally defiant suppression of the Epstein files is that the files contain information about specific individuals whose protection was worth more to Bondi than her office, her freedom, and her constitutional obligations. The impossible dilemma now consuming Pam Bondi is unlike any professional crisis any attorney general in American history has faced. And the people inside the Justice Department who understand what the impeachment process actually requires are describing the internal atmosphere with a single phrase: dead silence, not the strategic quiet of an institution managing a political attack. The silence of people who understand that the legal process now in motion cannot be deflected by the standard tools of institutional defense. Impeachment is not a lawsuit that can be litigated in friendly venues. It is not a regulatory proceeding that can be delayed through motion practice. It is not a congressional investigation that can be stonewalled with privilege claims. It is a constitutional proceeding conducted by the full House of Representatives, leading potentially to a Senate trial in which Bondi will be required to answer, on the record, under oath, in front of the cameras, the specific question the articles of impeachment have now made inescapable. What exactly is in those files, and who exactly were you protecting? The Epstein files are the gravitational center of everything that follows from this impeachment, and the public accounting of what those files actually represent remains catastrophically inadequate. The Jeffrey Epstein investigation was not a closed chapter. It was one of the most extensive federal investigations into elite criminal networks ever conducted, producing millions of pages of documentary evidence about financial transactions, travel records, communications, and personal associations involving individuals who did not stop being powerful when Epstein died in a federal jail cell. The names redacted from the documents Bondi's DOJ has released are not random. Congressional investigators who have reviewed even the partial disclosures describe a pattern of redaction so consistent and so specific that it reflects a deliberate, prioritized effort to protect certain categories of individuals. Individuals whose associations with Epstein, if fully documented in public, would generate consequences that Bondi has apparently concluded are more catastrophic than the consequences of an impeachment trial. That conclusion, made by the Attorney General of the United States, is itself the most damning document in this entire case.